Assistant Public Defender Chelsea Regios with and on behalf of Santana Taylor. Mr. Taylor, please state your name.
Santana Taylor. Thank you.
This case opens with a quiet courtroom, but what unfolds is anything but quiet. You're about to witness a chain of decisions that reveal how fragile freedom becomes when trust in the system collapses. At the center is Santana Taylor, a defendant juggling multiple cases, mounting charges, and a history that keeps pulling him back into custody. What starts as a routine request for more time quickly turns into a high-stakes debate over danger, credibility, and whether this man belongs on the streets at all. Listen closely to how the defense frames him. A son caring for a sick mother, a student trying to restart his life, a man worried about his dog. It's a portrait designed to humanize. But then comes the prosecution's response. A chilling timeline of missed court dates, violent encounters, and escalating behavior. Each side is painting a radically different version of the same person. Judge Simpson sits at the center of this tug-of-war. His job isn't to feel sympathy, it's to assess risk. Is this someone who deserves another chance outside a cell? Or someone who has proven repeatedly that court orders mean nothing? This is where courtroom drama becomes real life. Every bond decision changes the trajectory of someone's future, freedom or confinement, hope or consequences. And as this hearing unfolds, you'll see how quickly compassion can collide with cold, hard facts, and how one judge's words can redraw a man's fate in seconds.
What are we doing?
Your Honor, I would ask for an adjournment on all three cases. On the two newer ones, we're still waiting on some discovery, and just to keep them all together, if we could get a 2 to 3 week adjournment on all three, and if you would allow, may I address bond?
Go for it.
Thank you, Your Honor. So I understand currently he's got a bond on all three cases, and I would ask you to consider releasing him on a home confinement tether. My client stresses to me that the most important aspects of his life truly are in jeopardy if he is to remain in custody until his next court date. His mother is very ill. She has dialysis. He helps take care of her. Additionally, his dog is at home, and he's very worried about the life and well-being of his dog. He applied recently to Washtenaw Community College, and for HVAC classes, he would very much like to enroll in those and progress further in his life. I understand he did miss the last court date on February 27th. He expresses to me that he had strep throat at the time, and he went to urgent care for that. I unfortunately don't have documentation regarding that, but he did intend to come to court, although he was sick at that time. So being all these things, these are things that keep him here and that are really important to him. I would ask you to consider releasing him on a tether.
Sorry. Go ahead.
So this is a case, well, the first case is one where we requested a $100,000 bond because of the home invasion. Second, that is DV related. The defendant failed to appear for that case on December 21st, and a bench warrant was issued with $10,000 cash surety. Then the defendant failed to appear on January 18th, and another bench warrant was issued for $10,000 cash or surety. He appeared on February 8th and requested an exam for which it was set on February 27th. My understanding is that didn't happen because he had strep throat. While he was out on February 21st, he picked up a strangulation that is against a different DV victim. During that strangulation, he went to the victim's apartment while she was sleeping. She had put belongings of his outside her door for him to pick up. She woke up and because of him, and he began to argue with her. She then told him to leave. He pushed her, and she admitted she pushed him back. He then kicked her in the shin and choked her before pushing her to the ground.
This is where the temperature in the room changes. The prosecution stops speaking in hypotheticals and starts speaking in harm. Strangulation, home invasion, repeated failures to appear. These aren't paperwork mistakes. These are red flags that judges are trained to treat as predictors. Strangulation, in particular, is one of the most dangerous indicators in domestic violence cases. Courts know it's strongly correlated with future lethal behavior. That's why prosecutors emphasize it. They aren't just describing an event, they're establishing a threat profile. Add to that the false ID, the foot chase, the brass knuckles. This isn't a man simply struggling with logistics. This is a pattern of defiance and escalation. When a prosecutor lists prior convictions, especially violent ones, they're not trying to shame. They're answering a single question. What happens if we let him walk out today?
She said that she was lightheaded and struggled to breathe while he strangled her. In that case, we requested $100,000 and were only given $5,000, 10%. That offense date is February 21st of 2024. He was not apprehended on following that incident for which he was not apprehended. The defendant then picked up another charge of R&O. The offense date on that was March 19th of 2024. He was seen wandering around a closed car dealership, and when he was confronted by police, he gave them a false ID. He then ran from a sheriff deputy, causing Deputy Cuso to give chase, during which he was injured in the process. Only when Deputy Phillips was able to apprehend him. He was also found to have brass knuckles on his person. In that case, we requested $25,000 cash or surety and were given $1,000 with 10% privilege. My concern is
Really?
not only the 3 cases for which he has had multiple failures to appear, multiple bench warrants. He also has a hold out of Canton for $500, a 2002 conviction for home invasion second, a 2006 conviction for CSC fourth, and a 2003 conviction for OWI with an occupant under 16. At this point, I think that the bonds as set are an abuse of discretion, and I would ask for them to be raised.
Response?
I would definitely argue against them being raised. You know, my hope was, of course, to get them lowered, but
I know. We all have our hopes and dreams. And actually, the
Yes.
100,000 I set,
so
finding already an abuse of discretion with the setting of that bond. Motion for bond reduction is denied. Bond will continue in each case. I'll do you the favor of not raising the other bonds.
That line lands like a gavel strike. Abuse of discretion. Judge Simpson is signaling that the defense didn't just ask for too much. They misjudged the room. And when he says, "I'll do you the favor of not raising the other bonds," that's judicial restraint layered with warning. Translation, you pushed. You almost lost more. Bond isn't about guilt. It's about trust. And this defendant has burned that bridge repeatedly. The court isn't punishing, it's preventing. Here's the question for you. Should bond exist primarily to ensure court appearance or to protect the public? Because this ruling answers that question decisively. Judge Simpson isn't swayed by future plans. He's anchored in past behavior, missed dates, new charges, escalation. To him, lowering bond isn't compassion, it's negligence.
Thank you.
thank you, Your Honor.
April 11th, 2024, 9 a.m.
State your name for the record.
C. Gill.
All right, thank you.
Your Honor, we would be doing an order for competency on this one.
You're requesting a competency evaluation.
Yes. And if we may ask to address bond when possible.
Forensic evaluation is hereby ordered. I'll set a competency hearing for, give me 60, but I don't know what's going to happen.
May 30th, good night.
May 30th, 2024, 9 a.m. As to bond.
As to bond, Your Honor,
Do you
Mr.
have the orders prepared, or
Yes, I do.
you're just going to hold them? Go ahead.
As to bond, Mr. Gill is a 82-year-old who has health issues. There is a order for temporary guardianship and conservatorship that was entered yesterday. We'd be asked that he be able to be released to his guardian, Melanie Ellis, who's located inside Plymouth, Michigan, while this case is pending.
Your Honor, we have, our original request in this case was $25,000. The grant or the bond was set at $25,000 with 10% privilege. I understand that there was a request for guardianship or conservatorship. yesterday, the guardian and conservator has refused to take the defendant into their home because of the abuse the defendant has perpetrated against his wife throughout all of the children's lifetime. We have also received additional statements from the children today that are in excess of 15 pages outlining the lifetime of abuse that has occurred over their 50+ year marriage. This is a strangulation case where the victim is 80 years old. He grabbed her by the neck, applied pressure, pushed her onto the couch, and was on top of her. The only way she was able to get him off was by physically pulling her knees to her chest and kicking him off of her. The only reason she reported this was because she told her pastor, and her pastor at her church said that she was not equipped to handle this type of situation, so she encouraged her to go to the police.
This is heartbreaking. An 80-year-old victim, a lifetime of abuse documented by her own children, 15 pages of pain that never reached a courtroom until now. And notice how the prosecutor frames it, not just as an incident, but as a pattern stretching across decades. When victims wait this long, courts take it seriously, not because memory is perfect, but because silence over decades often signals fear, dependency, or normalization of harm. The guardian refusing to take him in is critical. It removes the illusion of a safe landing. There is nowhere he can go that doesn't expose someone vulnerable. This isn't just a bond hearing anymore. It's a safety decision for an elderly woman who finally spoke. Judge Simpson isn't just ruling on a man's freedom. He's deciding whether the system will shield someone who has already endured a lifetime without protection. That's the weight of this moment.
I'm extremely concerned if the defendant is to get out, that there is a high lethality situation.
Well, hold on. He doesn't have a place to go, right?
I do not, unless my daughter would take me.
She said no.
But that's the daughter, that's the guardian.
I believe so, yes, sir.
But my understanding is that's not going to happen.
Correct.
I don't have any place to go.
All right, Your Honor, at this time, we would withdraw our request, and then if any.
Thank you. I'll have his bond continue and see if you can figure out something, but
Okay.
they don't.
May I ask a question?
You can always ask. I don't know if I'll answer. Go ahead.
I had the money in the bank, but I just couldn't access it because I didn't have, I don't know. I just didn't have the ability to access the $2,500. I had it, probably.
But hold on a second.
I'm sorry.
I don't know. Was it a conservatorship and a guardianship?
Yes,
So he doesn't really have access except through somebody else anyway.
Can I say
Yes.
something?
This exchange reveals how law collides with reality. Guardianship means control is gone, even over your own money. The defendant isn't lying about having funds. He's legally blocked from them. But the court still can't bend around that. Judges can't restructure civil guardianship from the criminal bench. They can only work within the framework in front of them. And this is where fairness feels cruel. You can hear confusion. You can hear frustration. But procedure doesn't pause for personal chaos. The court offers a future motion, not immediate relief, because even when the system empathizes, it moves in steps. Slow, rigid, formal. This moment shows you what due process really looks like. Not dramatic, not emotional, just procedural gravity. And for defendants like this, the process itself becomes the punishment.
well, I would, that's not, then we can submit a motion at a later date to modify.
But I might,
Until we figure it out. We got some more.
because I got the money for the bond, I just couldn't access it because they did it.
I'll come see it. Okay. Your Honor, we're all set.
Thank you. Continue.
Yeah.
Good afternoon, to your staff, Jonathan Emmons on behalf of the people.
Yeah, if you're up. Hey.
Did you want to like this?
Hey, Judge, let's start you. Come on. Come on. Did you want to fight me? He can hear you, Your Honor.
All right. Mr. Heft, you are before the court on a felony complaint that alleges that on or about September 25th, 2023, the location of 2325 Twin Lakes Drive, apartment TA.
New case, new defendant, and instantly the courtroom feels different. This isn't a loud bond argument or a prosecutor reading a violent timeline. It's the eerie kind of tension where the judge is speaking and the defendant barely responds. And that silence matters. At arraignment, the judge has to do a few core things: read the charges, confirm understanding, advise of maximum penalties, and protect the defendant's right to counsel. Even if someone refuses to talk, the court still has to build a clean record because later on, appeals get built on tiny procedural errors. Judge Simpson is basically making sure nobody can claim, "I didn't know what I was charged with," or "I didn't understand my rights." But it's also a practical problem. When a defendant won't answer, the court can't assess comprehension in real time. That's why you hear the judge repeatedly asking, then eventually moving forward anyway. Courts aren't allowed to stall forever. They document the silence, make reasonable assumptions on the record, and proceed. So here's the engagement question. If someone won't respond in court, should the judge slow everything down until they do? Or keep the system moving to avoid creating delays and chaos? This is the uncomfortable reality of criminal court. It has to keep going, even when the person at the center isn't fully participating.
Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of aggravated indecent exposure. Sir, do you understand the nature of that charge? Do you understand what you're charged with, sir?
You understand your motherfucking queers, bitch. Quit fucking stalking me, you fag ass motherfucker.
I will take that as a yes. That is a misdemeanor, a high court misdemeanor, punishable by up to 2 years and or a $2,000 fine plus court costs. Do you understand that?
Queer ass piece of stock ass shit, motherfucker.
Sir, do you understand the maximum penalties?
Yeah, you can fucking open up the fucking door, bitch, like that. Bitch, stock ass motherfucker.
Defendant is responding. It's inaudible, but I believe that he understands the maximum penalties. Count 2 is a misdemeanor offense that alleges that on that same date and at that same time that you did commit the offense of indecent exposure. Do you understand that charge, sir?
Hey,
I'm not hearing a response. He is present in the area.
he is present and listening, Your Honor.
All right. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. I will ask, although you're not responding, Mr. Heft, do you understand the nature of that charge and its maximum penalties? Do not hear a response. I will assume that the defendant has heard the charges and the maximum penalties. I will ask you first, sir, do you wish to be represented by counsel? Mr. Heft, do you wish to have an attorney represent you in this matter? I'm not hearing a response, but given the nature of the charges, the court, to protect the defendant's rights, this becomes a public defender case.
This is textbook judicial safeguarding. Even with zero response, Judge Simpson appoints counsel because the stakes are real. 2 misdemeanor charges, but one is a high court misdemeanor with up to 2 years. That's serious exposure. And if a defendant is silent, confused, mentally ill, or just uncooperative, the court errs on the side of protecting their constitutional rights. This is also why standing mute exists. Defense attorneys sometimes do it strategically. They don't admit anything, they don't argue facts, they preserve issues, and the court enters a not guilty plea automatically. The system is designed so you don't have to perform your innocence on day one. You're presumed innocent, and the state carries the burden later. Also notice the scheduling. Probable cause conference first, then preliminary exam. That's the pipeline. The court is setting the chessboard early.
Bridget Cook, on behalf of the Public Defender's Office, for Mr. Heft.
You waive any further formal reading of the complaint.
Yes, we waive formal reading and we stand mute.
Defendant, every waive formal reading, standing mute to the charges. Court will enter a not guilty plea, demanding a preliminary examination. You waive timelines on this.
Yes, Your Honor.
All right. Timelines haven't been waived. I will set a probable cause conference.
April.
It ain't gonna matter. But
March 28th or April.
let's do April 4th. Could be a better month. Set probable cause conference for April 4th, 2024. That will be at 9 a.m. and his preliminary examination will be set from that date. As to bond in this case.
Your Honor, as it relates to bond, I think that Ms. Coons will be presenting the court probably with a motion for an order for finding of competency or a competency examination. I'll tell the court I was familiar with Mr. Heft in 15th. I'll note that he was found in that case. He had a misdemeanor malicious use of telecommunications service. That case, he was found opined originally to be incompetent to stand trial, but restorable. That's a 6-month misdemeanor. So not surprisingly, the Center for Forensic Psychiatry was unable to see him within that 2-month period of time. That time frame elapses, he is then found to be incompetent. He doesn't have a lot of resources to his name. I'll be upfront with the court. I spoke with his mother a handful of times. I recognize that he has an illness, and I've tried to figure out act in his best interest using his mom. As I understand it, he doesn't have any family that are willing to kind of stick up for him, except for other than his mother. I'm asking the court for a high cash bond, $10,000, $50,000, only in so much as a way, and I'm saying this deliberately, not that I expect him to be able to post it, but I'm asking the court to consider it so high so that the mother doesn't feel obligated that she has to post it for him. I'm asking the court to put it in such amount so that she can't post it on his behalf. I don't believe that she's equipped. I've spoken to her. She's obviously a mother stuck between the love of her son and kind of everything that's going on. As I understand it, he has a 20-year history of schizophrenia. I don't think the court saw it while you were reading him the charges, but he came up and he punched the window during the reading of the complaint.
This prosecutor is doing something very calculated and honestly very human at the same time. He's saying, "Judge, I want a bond so high that the mother cannot rescue him." That sounds harsh until you understand what he's really arguing. He believes the mother is trapped in a moral hostage situation. He's painting her as a caretaker with love but without capacity, and he's warning the court, if she posts bond, she becomes the safety net for behavior she can't control. That can put her in danger and keep the cycle alive. He's also stacking facts to justify risk, past failures to appear, vague connections to other states, public outbursts, exposure allegations, and escalating instability. Even his detail about punching the window during the reading is meant to show impulsivity and unpredictability, not as an insult, but as evidence.
I believe that given the nature of these charges, this is a case where he was making homophobic, racist slanders from the porch of his apartment complex, which he doesn't reside at anymore. I believe he surrendered that apartment. And then he got people's attentions. They were able to use their cell phone video, record him as he was making these statements out loud in the courtyard, and then he exposed himself and gratified himself in an indecent manner. So I think he presents a risk of harm to himself, a risk of harm to others. He's got some vague connection through his Facebook account to Mesa, Arizona. He does have a previous history of failing to appear. I think that there's a lot of issues that go on. Underlying all of it is that he's mentally ill.
Jenner, I do have an order for competency. We would be asking for some type of nominal bond if he's possible to post it. He does have the support of his mother. He did have.
Well, you're asking for a forensic evaluation.
Yes.
I don't know how. I'm not going to sign that at this time. And the only reason I'm going to sign it, I'm not sure, unless your office has dealt with him. I understand the other orders that you'd be in a position to make that or a request of the court to make that referral. So I'll set his bond at this time. I'll set it for the PCC. We can deal with it at that point. I'm going to set his bond. Yeah, I saw him. $50,000 cash surety, standard conditions, including no assaultive behavior or use or possession of weapons, no alcohol, recreational marijuana, or any illegal drugs.
Judge Simpson just made a decision that reflects one thing: uncertainty equals restriction. He refuses to sign off on a competency order in that moment, then pivots to bond and sets it high with strict conditions. Why? Because until competency is resolved, the court can't confidently rely on the defendant to follow rules. And the court's job is to manage risk in the meantime. Also catch the conditions: no assaultive behavior, no weapons, no alcohol, no marijuana, no illegal drugs. That's the judge trying to remove accelerants, anything that increases volatility. But the reality is, conditions only work if someone is capable of complying. When mental illness is severe, compliance isn't just a moral choice. It's often a clinical challenge. So this bond is almost a holding pattern. We're setting guardrails until we know what we're dealing with. And that's why these cases feel messy. The court is trying to run a legal process through a human crisis.
And I've signed that off. We're all set. See him April 4th. Thank you, Washington County Jail.
Thank you, Your Honor.
Court calls the case, People versus Chloe Whitsett.
Edward Drukas on behalf of Chloe Whitsett, who is approaching, Your Honor.
I'm sorry, Your Honor. I'm dismissing my court-appointed attorney and representing myself.
Okay, so start with this. What's your name?
Chloe Whitsett.
Okay. And you're intending upon representing yourself in this matter?
At this time, yes, Your Honor, I am. I am dismissing the court-appointed attorney at this time, yes.
Okay, what's going on?
Until my family and I decide what law firm we are going to choose, I will be representing myself.
Okay, all right. So you need time to seek a attorney?
Well, not really, but I have a request at this time as I am representing myself.
Well, not until such time as I relieve Mr. Drukas.
Okay, thank you.
That's what I'm trying, I have not done so.
Okay.
So I'm trying to figure out what the issue is and what you're intending upon doing.
Dismissing the court-appointed attorney and representing myself.
Okay.
I'm sorry, at this time. I can't make it any clearer, and I don't understand.
You're not making it very clear to me at all.
Okay.
You're not listening.
I'm
Just
confused.
talking. Are you going to hire an attorney?
Yes.
Or are you going to represent yourself?
Today, Your Honor, I'm going to represent myself. If my request is denied by you, then I will be hiring an attorney. I can't make it any clearer than that.
So so if I relieve Mr. Drukas, you're going to represent yourself?
Yes, sir.
So if they set it for a preliminary examination, you're ready to go?
This is I'm representing myself today. I don't know what all happens today, but I'm talking to the judge without the court-appointed attorney.
No.
Okay, well, I don't.
Listen. You don't you dare just lean on my podium and pretend like that. Not here.
And here we go. This is peak courtroom control. The second Chloe starts pushing boundaries, Judge Simpson slams the brakes. The podium isn't just a piece of furniture, it's symbolic authority. When a defendant leans, bangs, or acts dismissive, judges read it as contempt, disruption, and a preview of how they'll behave if given more space. This isn't the judge being sensitive. This is the judge preventing the courtroom from turning into a stage show. If one person is allowed to act out, the whole room loses structure. Also note the warning, you're going with Mr. Allen. That's a direct reference to being taken into custody. Judges often use that as a hard boundary, not as a threat for entertainment, but as a tool to restore order instantly. Engagement question. Do you think judges should tolerate more emotion and confusion from defendants who don't understand the system? Or does that open the door to chaos and disrespect? Because this moment is the line. The court will explain things, but it will not be bullied.
Okay, here's what I'm gonna do. I'm gonna pass the matter because if you come back up and start banging your nails on that podium, you're gonna be going with Mr. Allen. You may have a seat. Don't shake your head at me. Oh. Mr. Allen, might want to have a conversation with her and tell her that she better check herself before she comes back up here. Thank you, Mr. Durkin. Okay, so who wants to go next? Christian Philippe. Recalls the case, People versus Whitsett.
And Edward Drukas on behalf of Chloe Whitsett.
Your name.
Apologies on behalf of my client for earlier. I did have an opportunity to speak with her during that break and go over the process of where we are, what's going on right now. She did tell me that she would like to obtain a new attorney. So in the meantime, I can assist her with getting a copy of the discovery, getting a copy of the videos, which I don't have yet. I was going to be asking for an adjournment today to obtain those. So ultimately, I'd be asking for at least a 2-week adjournment. And I talked to her about her behavior in court, and I think that she has an understanding of that and will abide by anything the court orders her to do. So with that, I'd be asking for an adjournment of today's hearing.
Is all of that correct, Ms. Whitsett?
Your Honor, I would like to apologize. I had complete zero understanding, but yes, that is correct.
Ms. Whitsett, let me tell you something. I should have locked you up. You're lucky that I just took a deep breath and said, I don't know what's going on. I'm just asking her questions. And you come in here, I don't think we've ever seen each other. And you just come in here disrespecting me in this court. And I'm going to tell you something else. That man standing beside you right now, it's the only thing that saved you from going to jail. I had pretty much made up my mind that when I came back out here because of what you had done, you were gone.
This is one of those moments where Judge Simpson makes the courtroom feel like real consequences. He's telling Chloe, you were seconds away from being locked up. And he's not exaggerating. Judges can hold someone in contempt for disruptive behavior, especially when it interferes with proceedings. But here's the deeper lesson. Her court-appointed attorney just acted as a stabilizer. Even if she doesn't like him, his presence signals to the court that there's still a professional channel. When defendants go pro se, represent themselves, the risk of chaos goes up. Judges know it, prosecutors know it, and frankly, the defendant often learns it the hard way. The judges have long memories line is not a joke. It's a warning about credibility. Court is one of the few places where your attitude today can quietly shape how every future request is received. Adjournments, bond modifications, even how patiently the bench listens. She walks out of this moment with something more valuable than an apology, a second chance, and it came with a receipt.
So while you may not want him representing you, he just saved you. Remember one other thing. Funny thing about judges, we have exceedingly long memories. You come in here acting like that on the next day, I'm not even going to ask any questions. You are just going to go. Are we clear?
Yes, Your Honor.
April 11th. 2024. 9 a.m. as your invite indicates. It's time the defendant's bond will continue.
Let's wrap what we just watched, because this hearing was basically 3 different stories about the same system. Case 1, Santana Taylor. The defense tried to sell a redemption arc. Family responsibility, education, tether, I missed court because I was sick. But the prosecution brought a timeline of failures to appear. Violent allegations including strangulation and prior convictions that make judges think in terms of danger and repeat behavior. Judge Simpson ruled like a risk manager. Bond reduction denied, and he explicitly refuses to reward unreliability. The ruling signals a broader principle. Once the court's trust is broken repeatedly, sympathy stops being persuasive. Case 2, the elderly strangulation situation with guardianship layers. The court confronts the reality that even a release plan can collapse when family refuses placement due to long-term abuse. Bond continuing there isn't about paperwork, it's about preventing a high lethality scenario. Case 3, the non-responsive defendant and mental health concerns. You saw the court protect rights, appoint counsel, and set bond high with strict conditions while competency issues loom. It's the system trying to hold structure while the human situation is unstable. And then Chloe, a defendant learning in real time that court is not a negotiation of attitude. Judge Simpson makes it clear, disrespect equals jail risk, and attorneys often protect defendants from their own worst instincts. Bigger takeaway, bond decisions aren't about who talks best, they're about patterns, safety, and credibility. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.